Hello friends, I'm Ravi Somani. I'm a chartered accountant. Today we'll be discussing on one of the important judgments rendered by Gujarat High Court dated 6th of May 2022 in the case of Munjal Manish Bhai Bhatt, wherein the High Court have quashed uh, the deeming fiction of one-third value that is being considered for the land in the real estate transactions. Now, what was happening is that in case of real estate transactions, that is sale of residential flats or commercial flats, GST law has specified that the deduction towards the land component, generally these units are sold along with the sale of land, either as a land or as an undivided share of land. Now, since there is no GST levied on the land portion, the GST law provided for one-third value deduction towards land and rest towards the construction service. So how this one-third is arrived? What is the basis or mechanism of why only one-third? Why not two-third? Why not three-fourth? Why not one-fourth? So the entire that is exactly is being challenged in the Gujarat High Court as to what is the system or mechanism or how fair is it to keep one-third land deduction value and charge GST on the two-third portion. To give an example, uh, the quantum of value that needs to be deducted towards land requires various other aspects also to be looked at. For example, if the property is constructed in Bombay or Pune or Delhi or any other large metro cities or a posh area of a particular city, then certainly the value of land would be much higher. It goes as high as 80-85% of the total cost. On the contrary, there are certain areas where it can be as low as 20% or 25%, even 10%. It also depends on nature of construction. What is the type of construction is being carried out? Is it affordable housing or it's a premium housing? It also depends on the quantum of construction. For example, whether the construction is to complete the end-to-end project or to give it at a certain stage and from there the buyer would be doing the construction. So multiple facets go into deriving at the value of land. It also depends on the type of project. For example, whether it is a villa project or it is an apartment project. We all know that in villa project, the land value would be substantially higher because uh, the users would be lesser in the community, leading to higher cost of land being borne by the flat owners or the villa owners. So these aspects, without being considering these aspects, it was the one-third value was provided as far as the land deduction is concerned. Now, in this particular case, what has happened is that associate has filed for refund. The petitioner has filed for refund application, which was denied, and there were other set of petitioners who actually went for advance ruling, which was negative. So all these petitioners went to the Gujarat High Court filing a writ petition on this particular matter. Now, in the case of Munjal Manish Bhai Bhatt, uh, uh, there was a single agreement, but there was separate pricing given for land as well as for the construction. So this is, the facts of the case. Now, very important aspect that we must note: the various grounds that were taken by the assessee or the petitioner in this matter as to why this land deduction of one-third is not correct or arbitrary. So first and foremost important ground that was taken is that delegated legislation cannot travel beyond the main legislation, that is statute, main act. Now under GST law, there is no such power given or there is no such mechanism given to notify by way of a notification and provide for the value towards land deduction. This has been categorically pointed in by the petitioner, and this is already a settled jurisprudence in the case of Indian Express newspapers held by Supreme Court. Next, very important aspect that has been brought out is that in the 14th GST Council minutes, the council members themselves have discussed this matter and they themselves thought that this is going to be arbitrary and this will be challenged. In fact, Gujarat Deputy Chief Minister it is coming out in the minutes very clearly stated that this one-third land deduction would be litigated in future and could be arbitrary. And it was actually discussed that there must be a separate mechanism for apartments and for villas. But unfortunately, at the conclusion of the meeting, there is no backup as to why this has been concluded. So this is very clearly coming out from the government's GST Council minutes itself. Next, very important aspect that has been brought out in this judgment is a legislative history. As to what is the legislative history behind this entire thing, and how the law has evolved. It has all started right from Gannon Dunkerley in 1958, wherein Supreme Court for the first time held that there's a difference between works contract and a simple sale contract. Sale simpliciter. Works contract works on a theory of accretion, and on the other hand, the simple sale contract would work on a theory of a particular chattel sold as a chattel. So that is where Supreme Court held that works contract cannot be levied to sales tax. Now, after that, government had to make an amendment in the Constitution of India by way of 46th Amendment, wherein this was considered to be a deemed sale, and then the sales tax was levied on the works contract service. However, the matter again came before the Supreme Court in the Gannon Dunkerley case 2 in 1993, wherein the question came as to what should be the value of the goods element in the works contract, because in the works contract there is a goods and there is also a service, and what should be the value of the goods, wherein it was held that value of the goods must be arrived based on the books of accounts. The labor portion and the profit portion needs to be excluded, and value needs to be arrived based on the books of accounts. If it cannot be ascertained, then the law can provide for some standard valuation. So here it is very important. What Supreme Court says is that first the value must be arrived on actual basis, and if the actual basis cannot be arrived, only then they can go for the standard valuation as given in the law. After that judgment, almost all the state VAT laws provided for standard valuation in respective state VAT laws. But in all the cases, there was always a choice given to the assessee to look at the actual valuation, and only if the actual valuation is not ascertainable, they could adopt for the standard valuation, which is a deviation in the GST law. Then there was a Suresh Kumar Bansal, another landmark Supreme Court judgment which was relied upon, stating that where the levy of service tax on the flats which are under the abatement scheme was held to be invalid because there was no valuation mechanism, where the deemed deduction of 25% or 30% as an abatement was done without having a proper empowering mechanism of providing the value. Very important judgment that was relied upon was the judgment in the case of Wipro Limited, Supreme Court judgment, wherein under customs there was this valuation mechanism of one person to be charged as loading and unloading charges, irrespective of the actuals. Now, Supreme Court has held that this one person standard valuation is not correct. You must give assessee a choice. Only if the actual valuation is now not there, in that case you can go for the standard valuation. So this judgment has been heavily relied in this particular case. Now, another very important and a beautiful aspect that has been looked at in this judgment is that in the law there is no mechanism to prescribe valuation by way of notification. As per section 15 subsection 1, the value can at the most be only transaction value. And if the transaction value could not be ascertained due to various reasons, the only mechanism where the valuation can be provided is it can be prescribed by way of rules under section 15 subsection 4. Now here, the valuation mechanism is not prescribed by way of rules, it has been prescribed by way of a notification. The important question that comes is it really a power given to provide for the value based on a note under the rate notification? So that is another, I would say, a big anomaly. Next very important aspect is department has heavily relied on Schedule 2 of the CGST Act, stating that Schedule 2 provides for mechanism to charge GST in these cases. Now here, We need to understand that the Schedule 2 is only a classification schedule. This has been amended. The law is amended effective February 2019. And this is exactly what has been argued, that the Schedule 2 cannot enlarge the scope of supply under Section 7 and Section 9. Very important argument that has been taken is that measure of tax must have nexus with the subject matter of tax. Rajasthan Chemist Association, Supreme Court. Now, in the garb of charging GST on the construction service, you cannot give a measure of calculation in such a manner that a item which is not at all taxable under GST gets also taxed. So this is very important argument that has been taken. Now, these are the arguments that have been taken by the petitioner in the judgment. However, when we were discussing in our office internally on this matter, long back, about 3-4 years back, we pointed out a lot of arguments that can be taken in this case. So another arguments which are not part of the judgment, but we feel that are valid arguments in this case is, one is that scope of GST law, how it can provide for a valuation mechanism for something that is not there in the GST. Where is the power under GST law or by way of a constitution to provide for a valuation of an item which is not at all leviable to tax under that law? Very important aspect. So there is no power under GST law to provide for the value of land. Very important aspect is that where there is no mechanism of valuation, the levy fails. This is a landmark Supreme Court judgment, BC Srinivasa Sethi. And let me tell you, under GST law, there is no mechanism provided to provide for value of composite contracts involving goods, services, and land. Very important. Next is that even if we, for the time being, we assume that Schedule 2 is applicable, we need to understand that if a law is not just arbitrary, if it is manifestly arbitrary, manifest arbitration has been brought out by Supreme Court in the case of Shaira Banu. If it is manifestly arbitrary, then even a legislation providing for such sort of an arbitrariness can be held to be invalid, unconstitutional. Shaira Banu, Supreme Court judgment. And next very important aspect is that this entire thing leads to excessive delegation of the legislative power. Now we need to understand that in India, the legislative power is with the legislators. The legislators can at the most give some powers to the executives which are procedural in nature, but giving the entire mechanism of deriving the valuation is clearly an excessive delegation of power to the executives. Devidas, Gopalakrishnan and others, Supreme Court judgment. Now let me tell you, as far as departmental submissions are concerned, they were largely harping upon the fact that we have tremendous powers under Article 246A of Constitution of India. This has been recommended by the GST Council. Heavily they relied on the Schedule 2, which was not even considered by the Supreme Court. They relied on VKC Footsteps judgment, stating that minor aberrations in the computation mechanism cannot lead to the entire structure being invalid. Supreme Court categorically mentioned that this is not just minor aberration, and VKC Footsteps was totally held to be distinguished in this case. One very important argument this department took is that if we give the assessee a choice to derive the valuation based on actual basis, then people would misutilize this rule and somebody would say 99% is my construction and 1% is land, and they would not pay GST. Oh, sorry, 99% is land and 1% is construction and they would not pay GST. But let me tell you, what court has very categorically mentioned is that in all cases where the value is not ascertainable, or if you feel that there is this sort of system would be coming in place, there is already valuation rules which is there in the law. If there is no, if it is not ascertainable, there is already valuation rules which provides for cost plus 10% model. If the same is so, overriding the valuation rules and providing separate value by way of notification is not appropriate. So again, this argument was also quashed by the Supreme Court. Finally, Supreme Court held this entire notification providing valuation of 1/3 to be arbitrary and not proper, and was squashed completely. So this is what was held by Supreme Court. Now we need to quickly understand what are the implications of this judgment. What is going to be the implication of this judgment in the long run? The implication of this judgment is that assessee can actually claim the deduction of land on the actual basis, and if they have the value ascertained, they can go for it. If they don't have the value ascertained, they can actually derive the cost of construction service based on cost plus 10% model as per the valuation rules, and rest can be considered as towards value of land. Very important that few action points which assessees are required to take now is have a look at for past 3-4 years as to what is that they have paid excess beyond 1/3 valuation by considering the value only as 1/3. And in all cases where the taxpayer has paid excess tax, they can actually make an application for refund. However, it is important to note that the tax must have been, the benefit must not have been passed on to the customer. Let me tell you out of experience, when the GST law got implemented, many builders actually collected only 6% from the customers and paid 6% out of their pocket, and they have actually taken the cost of taxes. Many builders, after the 1st April 2019, the new scheme, they were charging only 5% to the builders, but they were paying 12% to the government. And again, over there, they have taken the cost of taxes. Because of the market scenarios, circumstances, and advertisement and various schemes that are being rolled out, builders have actually given GST free flats, and this is how they have marketed their projects. So in all cases where builders have taken the cost of GST, they can actually make an application for refund. And let me tell you, the refund, they can actually almost go back uh, from today roughly 3.5 to 4 years, because the period between March 2020 to February 2022 is excluded for this purpose as held by Supreme Court, because it was a COVID period. So it's a very important action that a builder needs to take. Very important to note that Mafatlal case, in the case of in the case of Mafatlal, Supreme Court has held that you need to fight your own battle, which means that you cannot wait that only once the Supreme Court judgment will come, only then you will file a refund application. Then the refund would not be granted for the past period. The time limitation is only 2 years. However, if you have already filed an application now, and let's say in future Supreme Court decides this matter to be in favor of the assessee, which we strongly believe so, then this entire application where that is filed would be granted as a refund to the builders. So this is one very important aspect. Builders can also look at representing through their industry associations before the GST Council on this particular matter, because to the extent what I communicate to builders, I feel that they completely feel this to be arbitrary, and what the land value deduction actually does not represent the correct valuation. Builders can actually also look at filing writ petitions in case the matter, if the department is not accepting the ground based on the advance rulings, or the application is being rejected towards a refund. So I would say these are the aspects that are need to be looked at. There are few connected issues coming in because of this judgment. The valuation of joint development agreements straight away comes under a very big question. I would say, I would not be covering those in this video. I'll take that up later in some other video. So thank you all for patient listening. I hope it added value to your understanding of this entire issue.